Mr. Morelli.
Yes, thank you, sir. If I can give you a list of the next three bills we'd like to take up. On page 16, I'd like to go to calendar number 262 by Ms. Lepardo. Following that, calendar number 41 on page 5 by Ms. Jaffe. And then we'll conclude this package with calendar number 84 on page 7 by Ms. Mayer.
Clerk will read.
Assembly 7004, Calendar 262, Ms. Lepardo, an act to amend the labor law.
An explanation is requested, Ms. Lepardo.
Okay. Happy to do that. This bill includes child care as a compelling family reason for purposes of unemployment insurance. Unemployment insurance claimants who voluntarily separate from employment without good cause are ineligible for benefits. The labor law specifies that a compelling family reason constitutes good cause. What we're trying to do here is basically codify existing state law so that if someone can in fact prove that their lack of child care caused them to apply for unemployment benefits, that they would be granted those benefits. Sometimes it occurs, sometimes it does not. We're trying to get predictability here in the system.
Mr. Goodell.
Thank you, Mr. Speaker. Would the sponsor yield?
I will yield.
Ms. Lepardo, will you yield?
Yes, I will.
Ms. Lepardo yields.
Thank you, Mr. Lepardo. As you know, the cost of unemployment is paid for by employers. And there's an experience rating that employers pay. It's an adjustment to their premium based on how many claims they have. And the original purpose, as you know, of unemployment was to have those situations where the employer laid off somebody. And so the employee lost their job through no fault of their own. Now, if the employee quits through no fault of the employer, but the employee quits, walks off, says, I'm done, I'm not working here anymore, this bill would say they're still entitled to collect unemployment at the employer's expense if they're quitting for child care reasons. Is that correct?
That is correct, but it's not something arbitrary. Oftentimes, this is, in fact, viewed as a compelling family reason. It's not something someone does frivolously. The judge who reviews this case, and many have been reviewed to be legitimate cases, they are granted that unemployment benefit under the assumption that they will be diligent in getting back on track and getting their child care reinstated. But oftentimes, to no fault of their own, a provider will close, or the family situation that they were accustomed to goes away. So we're just trying to make sure that this is applied consistently. Case law has already shown that judges can make these determinations. We're not trying to tell judges what to do. We're just trying to say, please take a very close look at this and apply the standard uniformly across the board.
But you would agree, wouldn't you, that if an employee quits working because of child care issues, it may have nothing whatsoever to do with the employer, right? I mean, the employer may still be providing the same
True.
terms and conditions and everything like that.
That's right.
But when the employee collects 6 months of unemployment for leaving the employer for reasons that were unrelated to their employment, it's the employer that pays, right?
Yes.
Now, we've just passed paid family leave. So as I understand it, if someone has a baby, they can get 6 to 8 weeks of disability under the standard disability, plus up to 12 weeks of paid family leave once that's fully implemented. And if this became law, they could then take another 6 months off. So they would be able to take almost an entire year off for the birth of a child, of which all but the 12 weeks would be paid for by the employer, right?
Yeah, I know you're sort of running out there a lot of hypothetical circumstances. It's much simpler than that. All we're saying is that in certain emergency circumstances, when child care is not available, most courts have seen this as a compelling family reason. It's already being judged that way. We want to make sure that that case law is codified in state law so that it is applied uniformly across the board for people who unfortunately find themselves in this circumstance. Again, this is not something that we're trying to provide some carte blanche approach for folks to take advantage of the system. We just want this to be applied uniformly.
So if you have a great employer, good benefits, everything else, and an individual quits over a child care issue, how does the employer evaluate whether the failure to have child care was the result of a lack of reasonable efforts for child care, right? This kicks in. I mean, the claimant still has to make reasonable efforts. How does the employer even evaluate that?
I'm not sure that the employer does evaluate that. That is something that the unemployment insurance, I'm sorry, unemployment board would make that judgment. And many of them do. And many of them are very sympathetic and understand that it's not approached frivolously. Most people don't come to this just arbitrarily. This really must be sort of the court of last resort where they've had to take this decision to leave work in order for a child care concern. I don't know what it's like in your county, but it worries me and mine that these daycare slots are going away in record numbers, leaving people who have no family resources with no recourse. So, again.
The concern I have in my county is a lot of the manufacturing jobs are going away, and people are losing their employment because of the high cost of doing business in New York, including the high unemployment costs. And so now we say that you may be a great employer, but you're going to be paying higher unemployment because someone has a new child and they're not comfortable with the child care. Now, this only applies if the claimant couldn't find alternative child care.
Correct.
Can the employer come in and say, here is a daycare slot that's available for you. You could take this and continue to work for me. Is that a valid defense by the employer from paying these unemployment benefits?
People have to make a reasonable effort. There's an exhaustive process that goes on here to guarantee that someone isn't trying to game the system in some way. And again, as I said before, this is a routine examination to make sure that there aren't slots in the community, that there isn't a family member or some other setting that their children can be cared for in. So it's already happening, and I think that most people would prefer to stay working. Most people would prefer to have good quality, accessible, affordable child care. And in an instance where something occurs that they did not anticipate, we want to make sure that judges do their due diligence, which they do consistently across the state.
Some people are concerned that this type of legislation, which drives up the cost for employers of hiring people with children, because it increases the likelihood of an unemployment claim, which will result in a higher cost to the employer, will inadvertently result in discrimination against young women in particular who have children. How would you address that concern?
I think it's really unfortunate if someone starts approaching employment in this manner. I don't see this having a chilling effect across the state, that they're not going to want to hire people with children. I think this is perfectly reasonable and a just thing to be doing.
And this bill applies regardless of the size of the business, correct? And I mean, it applies just as well to a very small business as to a large business.
That's correct.
Okay. Thank you very much, Mr. Lepardo, on the bill.
On the bill, Mr. Goodell.
The employers in New York State are very frustrated because they pay a lot of costs that are outside their control. And what this bill says is that you may be the world's greatest employer. You may have a generous health care plan. You may pay great wages. You may invest thousands of dollars in training, job training for your employees. You may be there on a personal level to help them through difficult times, and every other way, you're a great employer. But if your employees decide they want to quit, walk off the job, they don't have to give you notice. They can walk off the job. Doesn't matter how key they are. Doesn't matter how much you want them. Doesn't matter how much you're willing to pay them. If they walk off the job because they don't have child care that meets their standards, you pay the unemployment. You pay a higher unemployment. You pay 6 months of up to half their salary on top of the 6 weeks they can take when they have a child under disability, or the 12 weeks of paid family leave. The paid family leave, of course, as we know, will be paid by the employees. I'm sympathetic to child care issues. I had kids myself. I have grandkids. I even have a great-grandchild. Not that the other ones weren't great, but I have one that's great. But it's our responsibility as employees, as parents, to make sure that we arrange the child care. It's not our employer's responsibility. It's our responsibility. I didn't go to my employer and get their permission to have kids, and I don't expect my employer to pay me if I have kids without making and giving thought to child care. So the primary responsibility for child care is the parents' responsibility. They need to take that responsibility, and we should not expect employers to pay the cost of 6 months of unemployment when the employer did nothing wrong, and when the employer is there offering a job full-time, desperately wants to keep the employee, and it's the employee who is unable to obtain whatever they need in their private lives for child care. So I am sympathetic for the need to provide child care, but I don't think we should make that a cost of the employer on workers' unemployment if the parents don't make arrangements for child care on their own. For that reason, I'll be voting against this bill. Thank you, Mr. Speaker.
Read the last section.
This act shall take effect immediately.
Clerk will record the vote. Ms. Russell to explain her vote.
Thank you, Mr. Speaker. As I've been working with economic development experts in my area, one of the areas that businesses that are looking to relocate to the area or to expand pay attention to is the availability of childcare and the capacity for a community to provide childcare so that businesses can prosper. It has been my experience that those good employers that we speak about that have good health insurance plans, that have flexibility in their sick time and personal leave and all those types of things to help out their employers, also find that the dynamic of childcare is something they pay attention to as well. Some of our businesses are going so far as to provide child care services in co-location with their business. So I guess when we're talking about the good employers in our area, they have already seen fit to start looking at how they can support their workforce, knowing how important child care is. So this is, I think, an opportunity to support those good businesses that we've been hearing about during this debate, because they will likely benefit the most, ensuring that their employees have access to child care, and those that don't, that aren't quote unquote those good employers, maybe will start thinking about supporting child care in their communities, and see that as maybe part of their corporate responsibility to help out those other small businesses. We've talked today already about the fact that child care providers actually can't charge what it costs to run a facility, but perhaps these well-intentioned businesses can come together and work with our child care community, those other small businesses, to understand, how they can mutually benefit each other. I cast my vote in the affirmative, and I urge my colleagues to do the same.
Ms. Russell in the affirmative. I'm trying hard. I'm getting ready to go through that period of Are there any other votes? Announce the results.
Ayes 79, noes 40.
The bill is passed.
Assembly 775B, calendar number 41, Ms. Jaffe, an act to amend the social services law.
An explanation is requested, Ms. Jaffe.
Thank you, Mr. Speaker. This bill would require local social service districts to provide parents and caretakers who are eligible for child care subsidies when care is necessary to enable them to get an adequate night's rest because they work the night shift and have a child under the age of 6 who is not in full day of school. It requires districts to provide a subsidy that would allow parents to receive the 8 hours of sleep. And this bill is important because it will assure low-income parents with young children who work the night shift and need child care that they can get adequate sleep and will be able to do so regardless of where they live.
Ms. Corwin. Ms. Corwin, we're going to wait a minute, please. Thank you. Please, Ms. Corwin.
Thank you, Mr. Speaker. Would the sponsor yield?
Certainly.
Ms. Jaffe Reels.
Thank you, Ellen. I see here in the bill, it specifically states the authorization for a subsidy shall be sufficient to allow a parent to obtain 8 hours sleep. It doesn't say up to 8 hours or the amount of hours they need. It just says 8 hours. What if the parent doesn't need 8 hours of sleep? What if?
I'm sure that could be determined with the discussion with the child care program.
Okay, because it's pretty specific saying to obtain 8 hours. So it sounds to me like it would be required to provide that amount.
They could determine. I'm sorry. Can you repeat that?
It's just, it very specifically states 8 hours, so I don't see where there's an opportunity for judgment or discretion.
Well, if they need it, they can get 8 hours of sleep. If they request it, they can get the 8 hours of sleep. And I'm sure that there could be discussions if they needed 6 hours of sleep. But this provides the opportunity that if they need it, they can have the 8 hours of sleep.
Sure. And I see also the bill specifically references a late shift. Is there a definition of a late shift? I mean, hours between 6 and 12 a.m. or?
Well, we're talking about in the evening after the late shifts are outside of the regular 9 to 5 time where daycare is, child care is usually provided. So we're talking about evening, late evening.
Okay, because the bill doesn't specify that, and it doesn't reference any other section of law where that would be defined. So I guess, so that's your interpretation of what a late shift is?
It's within the context of the law. There are late shifts and there are various shifts, and I think that's within the context of the law that's already there.
Okay, so a typical shift is, say, 9 to 5, so a late shift would be like a 6 till midnight?
Within the handbook, there is an understanding of a late shift within the social services.
Okay, so I know when I worked all the different shifts. So there was a 9 to 5, there was a 6 till midnight, and then there was a midnight till 8 a.m.
Right.
So other than the 9 to 5, the other ones would count as late shifts.
Well, these would be considered late shifts, and then they would be given the opportunity to be able to sleep, at the time during the day when at that time, the challenge is to be able to care for the children.
Okay. So they work their shift, say their shift goes from like 3 p.m. till 9 p.m. They only need a few hours sleep. They really don't need 8. Is there anything in the bill that would stop them from going out to dinner or going out to a party or whatever for part of that time?
Yeah, I wanted to just be sure that I'm correct. This is the subsidies for the day. It's during the day that you have the providers that are being, allow the family member to sleep during the day because they would be working the night shift.
Okay. So if they were
evening, so it would be during the day that they would be getting the opportunity to have a provider take care.
Okay.
Otherwise, they wouldn't really be able to.
Okay,
access.
so say they work a 6 p.m. till midnight shift. and they decide to, or I'm sorry, say they work till like 8 in the morning or whatever, and they decide they got errands to run, but they'll take the children to daycare during the day, and they'll go out and run errands or have lunch with a friend or.
That is probably unlikely. It is unlikely they would be going home, that the individual would be going home and going to sleep to be able to sustain themselves, to be able to then go back to work and care for their families.
Okay. Well, I know when I worked a midnight to 8 a.m. shift, I used to come home and I'd go straight to bed, and I'd sleep till about 10 a.m. because I couldn't sleep in the middle of the day. So usually I would try to sleep again later in the day, but it was kind of on and off. Usually I ended up going out and running errands and taking care of other business during the course of the day. So I guess my concern here is the language of the bill isn't terribly specific, and it doesn't really prevent that from happening. So I guess my concern here is the possibility for abuse of paying for child care because the person works an odd shift. However, that's not the purpose that they would be using it for. They'd be using it for other reasons.
Well, currently there are many districts that already provide this kind of assistance. I would say that 47 out of the 58 districts currently provide this, and it's already within the structure. But the problem is that if you live in certain places, you don't have this opportunity, and there is, it varies in terms of the hours that are provided. But what this will do is provide everyone, no matter where you live, the opportunity to have that time to sleep so that you can function. And I think there is a question as to whether they have to run out and do an errand and take a nap. I think that the chances are those who are working that late night shift and their child is then provided with the child care, that individual is going to sleep so they could function and work.
Okay. Thank you, Ms. Jaffe. On the bill, Mr. Speaker?
On the bill, Ms. Corwin.
I certainly understand, and this goes with all the legislation we've been contemplating today, the intention. And it seems pretty straightforward that we can write down, it's a couple sentences, maybe a paragraph of statute that we would be incorporating into our laws. The problem is you have to think of the hypotheticals. You have to think not in terms of what the intention is in that paragraph, but somebody else looking at it from a different perspective and using it to their advantage. This piece of legislation, to me, is particularly concerning because it's written so broadly, or there's no specifics to it. I think there's a lot of opportunity for misuse. For example, the definition of a late shift. I mean, in today's day and age, we don't have just 9 to 5 or 6 to midnight. Hours can be very odd, and they can be very different from day to day. Likewise, to say specifically 8 hours of sleep, not everybody gets 8 hours of sleep. As a matter of fact, studies show the vast majority of people sleep far less than 8 hours, whether they should or not, but that's the reality of today's lifestyle. The point being that, yes, if you are working a job and you have to sleep and the hours are such that you need to have the child in childcare, that's fine, but I think we need to tighten up the language here to make sure that people aren't going to use that opportunity to go have a good time with their friends, to go shopping, to do something they shouldn't be doing, and having the children in childcare and getting paid for by the taxpayer. So certainly I think there's an opportunity to improve the bill, make it a little more specific, and minimize the amount of opportunities for abuse. Thank you, Mr. Speaker.
Thank you, Ms. Corwin. Read the last section.
This act shall take effect April 1st, 2017.
Clerk will record the vote. Are there any other votes? Announce the results.
Ayes 80, noes 38.
The bill is passed.
Assembly 1864, calendar number 84. Ms. Mayor, an act to amend the social services law.
An explanation is requested, Ms. Mayor.
Yes, Mr. Speaker. This bill would provide the opportunity for child care providers to post their relevant training beyond the required licensing activities on the OCFS website. This allows child care providers to promote their relevant accomplishments and provides parents with more information on the child care program.
Ms. Corwin.
Thank you, Mr. Speaker. Would the sponsor yield?
So you certainly will as soon as we clear the path between you and her. Members? Thank you. Let's try that again, Ms. Corwin.
Okay, thank you, Mr. Speaker. Thank you, Shelley. I know we had a discussion on this bill last year as well, and I was just wondering if it was changed at all as far as verification. The bill very expressly states that the child care provider can talk about their educational credits, national accreditations, quality ratings, anything like that. Does the bill require OCFS to verify or confirm any of those claims before they get put on their website?
We didn't impose additional requirements on OCFS. If you look on their website, you'll see that they already post, for example, violations for each provider. There's a lot of information that is within their obligation. This is simply a posting requirement.
Sure, and I can understand wanting to give them the opportunity. You want to paint a full picture, not just the negative side of it from violations. I guess my concern here is that a child care provider can claim that they are of a certain quality rating. Parents coming to that website would assume it's a government website. They track, they oversight, provide the oversight for these agencies or for these providers, so that if it says that they're A-rated by such and such, well, then that must be true. I guess my concern is there's nothing here to prevent someone from putting false information on somebody else's website.
Well, I'm assuming OCFS, in designing the portal that you're going to look at, is going to say it's self-reported. So I think, we will assume OCFS will build in some advanced knowledge to the person who looks at the site that they're seeing self-reported data.
Okay, but this legislation doesn't require them to put that disclaimer in.
It requires them to post the data, but it doesn't describe exactly what they're going to say about it. So it certainly can say it's self-reported.
Okay, thank you, Shelley.
You're welcome.
On the bill, Mr. Speaker?
On the bill.
Again, it's a very quick little paragraph that would get added into statute. I think we have to be very careful here because I do believe by virtue of it being a government website, there's that implied sense that it's completely accurate or verified when in case it wouldn't be. So I would just recommend if we were to go through with this legislation that we tighten up the language a little bit to make sure that OCFS verifies or confirms, or at a minimum puts a disclaimer in there clearly enough so parents going to the website understand what they're looking at. Thank you.
Thank you, Ms. Corwin. Read the last section.
This act shall take effect immediately.
Clerk will record the vote.